It was great to see people lingering during the break and just continuing that conversation from that fascinating last session. So I was really glad that that was able to happen. Well, folks, you don't get to come to a conference on charity law without there being a session on political advocacy. It's a perennial favourite. It's a topic that just keeps giving and giving, or taking and taking, depending on your standpoint. And I'm very pleased to be able to welcome three very distinguished speakers to address us on this topic before we open up to Q&A. These are all very well known figures to the charity law world. Dr. Juliet Chevalier-Watts from the University of Waikato, who's written extensively on this and many other topics in charity law. She'll kick off with some comments. She'll then pass the baton to Jennifer Batrouney, AMQC, and Jennifer, of course, is a leading member of the Victorian Bar and has represented charities in a large number of leading cases. And then I'm very pleased to be able to welcome Kate Davenport QC. Hi, Kate, who joins us from Auckland, and Kate will offer some remarks after Jennifer. And Kate and Jennifer, as many of you know, have been active representing clans as intervener in the Family First case, which was recently heard in the Supreme Court of New Zealand. So thank you all three for being with us, and I'll hand over to you, Juliet.
Thank you very much. I hope everyone can hear me okay. Kia ora, everybody from New Zealand. And I am delighted to be here and so happy to see so many of you here as well. So I wanted to acknowledge the Waikato Tainui iwi, who are the iwi of the Waikato region in which I live and from which I'm speaking currently. And what I wanted to do was I wanted to talk about the 2020 Greenpeace decision in relation to advocacy and environmental issues. And I would argue perhaps that there was an inevitability about this particular decision because the progress of advocacy in relation to environmental issues, which is of huge concern right now in New Zealand, and you can't help but hear it hitting the news constantly. So as many of you will be fully aware, Greenpeace has had a turbulent journey through the courts over the years trying to re-establish its charitable status, and that journey concluded, at least I hope it has done, in August 2020, where Justice Mallon confirmed that Greenpeace's advocacy for the environment, amongst other things, was actually charitable. And just to give you a bit of an understanding, a bit of a perspective of what environmental issues are like here in New Zealand right this very moment. A couple of weeks ago, there was a baby orca by the name of Toa, who was separated from his family and washed ashore in Wellington waters in New Zealand. And this hit the headlines in New Zealand, potentially with yourselves as well in Australia. And there was much press attention from an environmental and public interest perspectives. Now, sadly, unfortunately, Toa did die despite extensive undertakings to save his life, but it was all to no avail. Now, Greenpeace themselves utilised the death of Toa as one of their launch pads to advocate for protecting the oceans. And that launch pad and advocacy were all over social media and the news. And indeed, many have suggested that Toa losing his family and his subsequent death can be placed squarely at the feet of humans and their damage to the humans, and then placing blame on the government, making it very political. Then there was the government's latest approach to tackling environmental issues in New Zealand with what is called the ute tax, which is, for those of you who don't know, this is the government's clean car discount, where from January, the policy will add thousands of dollars to the cost of some petrol and diesel vehicles, and the money raised will subsidise low emission vehicles. This has been hugely unpopular in many sections of the community, and it's been widely condemned by the farming, tradie communities, being counterproductive, unfair to their way of living. And indeed, there were many protests on the streets about this. Now, in amongst this background of the challenges facing New Zealand trying to uphold its clean green image comes the Greenpeace case to the High Court, where much of what was addressed by Justice Mallon was advocacy for the environment and whether or not this can be charitable. So, as you will undoubtedly know, historically, political purposes, advocacy, not charitable. And that all started with the Bowman and Secular Society case back in 1917, allegedly. And as in the UK, Australia, New Zealand, the same, followed that line of thinking. But then came the Supreme Court decision, 2014, of the Greenpeace decision, which determined that political purposes, advocacy, charitable purposes, not mutually exclusive. So coming back to the Greenpeace 2020 case, Justice Mallon, in this High Court case, noted that the Supreme Court case of 2014 laid down a three-stage test to assess whether advocacy or promoting a cause is charitable, which all relates to public benefit. And as such, this depends on the end that is being advocated, the means promoted to achieve that end, and the manner in which that cause is being promoted. Now, that all sounds fairly straightforward, but I agree with Her Honour, Justice Mallon, that actually the difficulty with that test is in its application. And it seems likely, and I agree respectfully with Her Honour, that the Supreme Court potentially made this decision-making process even more difficult now for a number of charities. And however, in Greenpeace's favour, and the theme that underpins my assertions is that the Supreme Court confirmed the protection of the environment has come to be regarded as charitable, but it does depend on the nature of that advocacy. But their honours in the Supreme Court did also confirm that protecting the environment will require a broad-based support, and that will often include participating in political, legal discussions, processes which can be charitable. And this echoes the promotions of, say, for instance, human rights, which is also charitable. That requires participating in political, legal issues. But it's the nature of the advocacy that may be at issue, as Justice Mallon, the 2020 decision determined, and that hadn't been considered legally before. So for Her Honour, in applying the three-stage test of the ends, the means, and the manner, for Greenpeace, the protection of the environment was the end, which can be charitable. But what is advocated, the means, and how that is achieved, the manner, well, the public benefit of those was at stake. And in very brief summary, I know, very briefly, what Her Honour confirmed was that their advocacy was indeed charitable. And it was difficult to argue against her logical approach to this, I think, in many regards, even regardless of how you might feel about some of Greenpeace's often controversial headline-hitting methods that they utilise to undertake their activities. So Justice Mallon looked at the public benefit of raising awareness of environmental issues, and even though there may well be competing interests, which there are, I just mentioned the ute tax, which we are going to have in New Zealand. Sure, there are competing interests, the farming community, the trading community. Does that mean it's incorrect? Does that mean it does not have public benefit? Well, if we apply Justice Mallon's approach, then it can still have public benefit, and that is because we are raising awareness of environmental issues to protect species. That includes humans, and that was what was determined in the Greenpeace case. We looked at the heart of Greenpeace's advocacy as set out in the court. What we are seeing is they advocate to avoid catastrophic climate change. Now, clearly, that has a political basis, inevitably, because of what has to have been undertaken by a government to ensure that we don't have catastrophic climate change. But international environmentalist Greta Thunberg, she sparked activism in New Zealand, whereby schools carried out public marches on the streets to raise awareness of environmental issues. That became political. And there was a call to place levy on single-use plastic bags, and that was raised by the mayors and schools, to which supermarkets responded. And Justice Mallon confirmed advocating against catastrophic climate change, which inevitably will impact adversely on humans, does involve things such as campaigning against fossil fuel usage and changing to clean energy, which is happening now in New Zealand, albeit with many protests, I do acknowledge. But that doesn't mean it isn't the right thing to do, even with those protests, and thus the public benefit is established. The same as Greenpeace advocated to protect oceans and rivers in the same case. And Justice Mallon again confirmed this is part of the broad-based approach to future-proofing the needs of Pacific Island nations. Even though the fishing industry will be impacted, even though farming practices will have to change, you know, with our enormous intensive dairy practicing, especially here in the Waikato where I live. And these have consequences for many communities, but raising awareness of environmental issues, which is what Greenpeace is doing, is a way of ensuring that competing needs are taken into consideration. Policymakers, farmers, fishing organisations, all of these make decisions. Without such advocacy, environmental impacts will be poorly understood or ignored, all at the overall expense of humans and their environment. So what this all harks back to is a point made by the Supreme Court in 2014 in the Greenpeace case. And what that was doing was ensuring that charity law remains responsive to the way in which society works. Now look, contemporary society throws up a whole range of issues, which was talked about in the break as well, that I was sat listening to. My assertion is that advocating for the prevention of catastrophic climate change that will have devastating repercussions for humans surely is at the heart of supporting the machinery or harmony of civil society, which is exactly what the Supreme Court spoke about in 2014. And in fact, there is nothing new in New Zealand legally in recognising protecting the environment. This was talked about in 2000 by the Centrepoint Community Growth Trust case. And in that case, Justice Cartwright referred to two cases from 1916 and 1918 with regard to protecting the environment. And Justice Cartwright confirmed that promoting a standard of living that doesn't exploit the environment and sustains a quality of life for future healthy generations would be for the public benefit. But obviously, from Greenpeace's point of view, they had the added issue of advocating for the environment, which likely would not have been charitable. But I would say that the Supreme Court in 2014 paved the way for their advocacy to be charitable through the ends, means, and manners test. And Justice Mallon was able to establish the nature of the advocacy through its means and manners that would benefit humans through ultimately protecting humans, would support public benefit through advocating for the environment. This then ensures, I would argue, that charity does support the machinery or harmony of civil society, which the Supreme Court spoke about, because if climate change
Your mute button accidentally went on there, Juliet, for a moment.
Let me just hit that. There we go. Sorry about that. So I would just wrap up by saying perhaps there was an inevitability in New Zealand for this High Court finding. Yes, it may well not necessarily been popular with regard to many groups, but that doesn't mean to say it wasn't necessarily right, at least from a legal perspective. And I think that Justice Mallon embraced the law and placed protecting the environment through advocacy within that legal framework, with the beginnings of such approaches taking root so many years ago, in fact, and culminating in this High Court decision. Thank you very much. And now I believe I'm handing over to Jennifer.
Hello, everybody. Might I also start by acknowledging the traditional owners? Can you first of all say, can you hear me all right? Okay. Could I start by acknowledging the traditional owners of the land upon which I am today, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders, past and present, and extend my warm welcome to those of members of clans in New Zealand watching us today. I have to say, you have caught me in a complete state of panic. not because of anything that's happening here, but because I've just been told that there's a very good chance we're all going to go into lockdown again. So I have just gone into a complete panic. But however, bearing in mind that I am in a complete panic, could I just talk to you a little bit about Family First, the Family First case? I am a director of clans and a member of clans, and the clans board decided that it would be a good idea if clans intervened in the Family First case. Now, Family First, as you may know, their name implies, they are an entity who advocates for the traditional view of marriage. They would say that they don't advocate against same-sex marriage, but that they say that the traditional form of marriage is the better form of marriage. They also, incidentally, advocate for against euthanasia and against abortion. Now, clans intervened in the case, obviously not to support either side, either the attorney who was seeking to, who was saying that Family First were not a charitable entity, nor in favour of Family First themselves, but simply in order to, in a nutshell, try and keep the door open so that the court would acknowledge that in certain rare cases, advocacy can in and of itself be a charitable purpose. So not just advocacy in relation to one of the first three heads, but advocacy in and of itself. Now, we say it's a rare case because cases like Greenpeace, the protection of the environment, cases like Latimer, where the Maori tribunal was held, that was a charitable purpose because it was maintaining social harmony, as it were. Things could be, advocacy can be charitable in and of itself. Now, so the hearing was held a month or so ago in the Supreme Court. It's interesting, Family First, still I think it's not clear whether they were claiming that their purpose was educational or an advocacy purpose. I think their argument was that their first argument was that they were eligible to be a charity because their purposes were educational, and then their second argument was that they were an advocacy organisation. Clans, as an intervener, it's not appropriate that clans sort of jumps in on every possible point that's raised by the court. Our submissions were quite confined to the point that when considering public benefit, in considering whether a charity is, the object is of public benefit, the court should have in mind not just the direct and indirect benefits, but also the wider benefits to the community. And one of those wider benefits to the community is advocacy. That is, generating public debate could in and of itself, in certain circumstances, be a charitable purpose. And we would say that could be in and of it. When I say in and of itself, that is regardless of the end for which it advocates. That is not, without opining or letting the court know at any stage what our view is about what Family First does. It's just the principle of the matter that in some circumstances advocacy can in and of itself be charitable. The attorney kicked off with what he called viewpoint advocacy. So this is some sort of slogan that nobody really knows what it means. But he says the question in the case was whether or not putting forward a position on a matter of public debate can itself be charitable. the attorney's position was that if so, a charity could include a political party and also self-interested advocacy by commercial entities. Now, that last aspect was not elaborated on in argument, and I don't think it could be, because I mean, I would suggest a commercial entity just wouldn't get past first base in being a charity. So I don't see how that follows. However, the attorney's argument was that advocacy towards a substantially accepted public good can, whether self-evidently or on the evidence, demonstrate objective public benefit. But this does not extend to advocacy for particular points of view on a range of matters in which there's no objective public benefit, nor does it extend to advocacy of viewpoints that are contrary to fundamental human rights. Now, I'll hand over later to Kate Davenport QC, who was kind enough to, together with myself, be pro bono counsel for clans, and Kate addressed the court in relation to the human rights aspects of the case and the discrimination aspects of it. But right from the get-go, the case effectively revolved around the line between education and propaganda. So right from the get-go, the Chief Justice's first question was whether the tendentious nature of the reports commissioned by Family First took them over the line into being clearly advocacy rather than education. And the attorney responded by saying that it was the tendentious nature of these reports that made them disqualifying. The attorney said that there can be no doubt that what Greenpeace was doing was advocating submissions in support of a charitable purpose, which is the protection of the environment. But he said that there was no charitable purpose in relation to which Family First were advocating. So that was something that Clans was asked, I think, about the break for lunch. I think on the first day, the court asked Clans if they would make some submissions to the court in relation to the line between education and advocacy. This wasn't something that we had prepared for, so there was a bit of scrambling going on. And we did make some submissions, which really at the end of the day, it's a very unsatisfactory area of the law, and I'm sure the academics on this conference will be desperate to say something about this. One of the leading cases in this area is the Henry George case, and Henry George was an economic philosopher whose view was that there should be a single tax. There shouldn't be payroll tax, income tax, capital gains tax, a single tax on land, and that was the best way forward for society. Now, the question came up before the New South Wales Equity Court as to whether or not that was charitable. And that brought up the distinction between education and propaganda. The court looked at the Draco Foundation case. Draco Foundation was a foundation established to inform, so it said, to inform people about how local government worked. And the way they did that is they had a virtual library, which is also what Family First claimed to have. And it was held in the Draco Foundation that merely self-study was not of educative value, was not advancement of education. Now, one can't help but wonder if the world's moved on in our COVID world, where that proposition would be sustainable now, where a lot of learning is done in our homes because we cannot go out. But the court also referred to Justice Hayden, who was in dissent in Aid Watch, And Justice Hayden said, the appellant's publications take a polemical stand in relation to climate change issues. Its stand may be virtuous, it may even be right, but it is not educational. He then adopted the words of Justice Hammond in Re Collier, where he said the conduct of the appellant represents an attempt to persuade people into a particular frame of mind. There is no instruction directed, nor is there any systemic accumulation of knowledge. So Justice Joe Williams, who's a good friend of the Charity Law Association, queried whether what we were saying was the more strident you are, the less chance you have of being a charity. To which I said, I thought that simply meant the less chance you have of falling within the education head. To which Justice Williams proposed, well, what about philosophers like Hegel, who he said, and I quote, are yelling at you on the page. These clearly accepted educators have extremely strident views, he said. So how can you say that just because you are propagating your view that therefore you are not educational? It's a difficult question to answer. It's certainly, and then of course Justice William referred to our own, well, when I say our own, we adopt him, Adam Parrish, and his writings about the Trinity West University, where students had to subscribe to Christian values. And again, I had to concede, well, there seems to be there's one law for the rest of us, and there's another law for the religious entities, at least in relation to propaganda in the charity world. So I'll be very interested to hear what the academics have to say about that line between education and propaganda. The last thing I just want to mention is fiscal implications. There were some, from my point of view, unsettling things said about the fiscal implications of allowing new charities, new charitable purposes. The Attorney General submitted that if you're being invited to really look at a new type of charitable purpose, which I didn't think we were, but anyway, then fiscal implications cannot be ignored, he said. And the authority on that point, he said, is overwhelming. Justice Williams again said that the problem with those propositions that didn't seem to bother the High Court in Australia in Aid Watch, where they had what he said, a radical widening of the law, and he queried the Attorney General's submission. He said, apart from the vibe of the Attorney General's submission, what can we say? He said, if this is going to be relevant, a bunch of judges who are not accountants or policymakers, aren't you going to have to give us some information about exactly what it is expected the fiscal implications will be? And are we capable of dealing with that in a way that is better than the Commissioner of Inland Revenue in a submission to the relevant ministers on law changes could? So, and Justice Glazebrook queried, well, are you saying that this will be catastrophic, for example, because there's going to be 50,000 people who are now wanting fiscal subsidies? And again, in relation to fiscal subsidies, they talked about fiscal subsidies being part of the social compact that leads to restraints on what charities can say. So Chief Justice Winkelman said, and we wouldn't have any difficulty, would we, in saying that a charity which proposes the idea that people who are redhead should not be able to be married is not of public good. So why would we have any difficulty in also resisting the idea that a charity that proposes the idea that same-sex marriage is not as important as marriage between a husband and wife? And the attorney said, well, it goes back to the social compact, the subsidy with respect, the aspect of the argument and the fact that by registration, there is a benefit and a status that has been conferred on these organisations. Plainly, there is financial benefits here, but the entities that seek charitable registrations are entering into a form of social compact in my submission, and in order to achieve that recognition, there is some constraints on what they can put themselves forward as supporting. As Chief Justice Winkleman said, and the law has developed a knowledge of how it defines a charitable trust has implications for public funds being effectively allowed to subsidise their activities. But as Justice Williams came back to say, but the contrary proposition is that banning redhead marriage is mad, but focuses on the traditional family and so on, are views expressed by a significant proportion of the community. Whether they are consistent with human rights legislation or not, they are not mad. They are relatively mainstream views, even if there's a lot of disagreement about it. It seems to me, he said, dangerous to discriminate against that view in terms of our constitutional and political arrangements as a democracy. So simply to say that your views are other than mainstream and that therefore in breach of some sort of social compact, and to mean that therefore you shouldn't get fiscal consequences is a big proposition, I would have said. So I'll leave that there. I'm sure people will have some questions in relation to that, and hand over to my dear friend Kate Davenport.
Thank you, Jennifer. Tēnā koutou, tēnā koutou, tēnā koutou, ina mahi hoa. Ko Kate Davenport taku ingoa. So I'm Kate Davenport. I was able to support Jennifer during the Supreme Court hearing on Family First, not by handing her pencils or anything useful like that, but simply being on a different Zoom call to her where we could occasionally have separate chats. But unfortunately, the Supreme Court hearing coincided with Wellington's lockdown, and I had been in contact potentially with someone who'd been in contact with an Australian, and so I was, like Jennifer, locked into a Zoom call, and that's a subject for another day. But I do think that advocacy suffers when you actually can't read the room, can't see what a judge is thinking, and really can't look at your opposing counsel and understand what they're thinking or going to say as well. But nonetheless, when the decision comes out, we will see the extent to which we were affected by this. So Jennifer and Juliet have talked a lot about the matters that were covered in Family First, and I want to talk on two things. First of all, the as yet undetermined point that Section 14 of our Bill of Rights Act prevents a subsidy from being withdrawn from a charity. And that really dovetails on a slightly different point, but similar point to that which Jennifer was making about the fiscal consequences of registration. And then I want to talk about the point which has been concerning me a lot. How, given the state of flux, do we advise our clients about whether or not an entity that comes to you wanting to be registered is likely to be able to be registered or not? And in our paper, we, for the Supreme Court, we did try to give it some structure, because I know as lawyers we like to have that kind of, if A, then B, then C worked out. And we stepped the Supreme Court through the process that they should ascertain. I think it would be fair to say that they didn't immediately pick up on that as being something that was going to resolve their problems, but it remains there, and I'm happy to share that with anyone who would like to see it. But I think that this case has illustrated very clearly the state of flux that New Zealand charity law is in. Sue Barker, our instructing solicitor, who deals a lot more than I do with the actual nuts and bolts of registration, tells me that the Attorney General and the officers of the Charity Board do in fact have a very strong view as to whether an organisation is charitable or not, and it's essentially anything which might be on the margins is out, and then you have to go through the quite expensive process of challenging the decision. So let's start first of all with the issues which relate to Section 14. Section 14 of our Bill of Rights Act says that you can't restrict someone's right to a freedom of political expression. And arguably, if you have had charitable status and then that is withdrawn from you, you lose the fiscal benefits of being a charity, which are significant because you don't have to pay tax and you have other benefits as well. But if you lose that, is that a breach of Section 14? So far, we really haven't found anyone that says that it is. There is a decision of the Canadian Supreme Court, which is slightly on point, and that's the AidWatch decision, where the Canadian Supreme Court knocked down a requirement that if you were a charity, you couldn't do any more than 10% of your work as advocacy work. And the Canadian Supreme Court, in Canada Without Poverty, said that you simply can't do that. That is unconstitutional. Now, we don't have anything like that in New Zealand. In the Court of Appeal decision, the Court of Appeal said, well, they didn't have enough evidence to ascertain whether or not Family First was suffering from the consequences of having their registration withdrawn, so they therefore couldn't make a decision. And there are a number of writers who say that withdrawing a charitable subsidy should not be something which can be challenged. And certainly in most countries in the world, the failure to grant charitable status is not regarded as infringing any right to freedom of political expression. But in America and other cases, there have been a number of cases which recognise that if you've had this charitable status and you have been free to utilise that, that status and the fiscal consequences of that, if you withdraw that status without proper purpose, then you are breaching Section 14. Now, unfortunately for me, since this was my part of the argument, the Supreme Court did not really want to hear any more oral argument on this point, but hopefully have read and digested the beautiful prose that we wrote when making their decision. But it's a very interesting point for me as a lawyer, and whether it turns out to have any particular significance to the definition of what amounts to a charity and what the consequences of that are remain to be seen. But because my part of the argument took up such a non-existent part of the debate in the Supreme Court, I would really like to, if we can, and I see from looking at the chats that we've had some interesting comments already about this point, but to engage the audience in trying to work out how one would guide a client who came to them with an organisation such as Family First, where they were expressing views that were not so extreme as to be banning one section of society, but certainly were no longer mainstream, such as an organisation, well, like a religious organisation that says, you know, for example, only those of the same religion can be married, and we want to be a charitable purpose for the purposes of advocating for both our religion and educating people on the benefits of that religion. Would that be a charity or not? So the step through that we came up with in our paper is to start with, first of all, the Constitution, or the other originating document which the entity that wants to be a charity has come up with, which should set out and state the objectives of the entity. And once you've had a look at that, you can determine whether or not they're charitable or not, one hopes, and then one can have reference to the activities which that entity undertakes. Now, as Jennifer keeps insisting, you can't have a charitable activity. You can have an activity which can be deemed charitable, given reference to the objects of the entity itself. And then you ask yourself, well, now that we've ascertained what activities this entity carries out and what its purposes are, do we think those purposes are exclusively charitable? If they're not, then you can't be registered as a charity. If you have some charitable and some non-charitable purposes, then you have to work out whether the non-charitable purposes are ancillary to the charitable purposes or not. And if they're not ancillary, then you're not a charity. But if they are charitable or only ancillary, then you have to have a look at the activities of the entity and determine whether those activities actually support all of the things which are stated in their purposes. And if they are, then we have suggested to the Supreme Court that that should be the end of the inquiry and they should be registered as a charity. But if they in fact have charitable purposes, but they don't carry out things which are consistent with those purposes, then you've got a state of what I think Matthew called mission drift. But we suggest that that does not affect the characterisation of the entity as a charity in light of its purposes. But we accept that that is potentially problematic. If you were, for example, an educational institute, but you proposed not to educate, but to do something else, then you might have difficulty convincing the Charities Board that in fact you were able to be registered. But then we come up against the question of what about entities whose activities are really political advocacy, such as Greenpeace. If Greenpeace had come to court 100 years ago, there would have been no doubt that it would not have been charitable, would not have been seen as a charitable entity. And so it's a trite but true to say that our definition of what is a charity changes with the way that society changes. And if we take no better example than the High Court of Australia decision in Aid Watch, where an entity which was quite political was deemed to be charitable because of its what was said to be its overriding purpose in relieving aid. Now, I know that some of those facts are not accepted, and certainly the minority decision in Aid Watch did not accept that what the organisation did was charitable. But it does show the move that society is allowing in terms of its own recognition of what amounts to charity or not. And if you look at the Statute of Elizabeth, you will see that one of the things that was deemed to be charitable then in 1601 was the marriage of poor maids. Now, an entity which now sets out to marry off poor maids probably wouldn't be regarded as charitable anymore, but who knows? If you could go back and say, well, it's always been the way, maybe in fact we would find that entities like Tinder and Hinge might now be able to apply for registration as a charity. So it has issues and difficulties, and I would be interested to hear what others have to say and what difficulties they've had in getting their clients' entities registered as charities. And Matthew told me about 2 minutes ago that I had a minute to go, so I think hopefully that's wrapped me up within the time allocated to me.
Perfect. Thank you so much. And thank you all three. There's heaps in what you've said, and that's now reflected in the chat. So do have a look at the various comments in the chat, but there are also some questions in the chat that I think we might start with. There was one that came out of your presentation, Juliet, but all three might want to say something to it. From Ian Murray. There was a claim being put in Greenpeace about illegal activities. Justice Mellon seemed to minimise the significance of these activities, Ian writes, and then he provides a quotation from Justice Mellon's judgment. which refers to the public benefit that might follow from breaches of the law, from civil disobedience, in effect. And so I wonder whether any of our presenters would like to say something on that. Yeah, Juliet.
Yeah, thank you for that. I do in some way agree that actually it looks like illegal activities were potentially really given, given this minor consideration. Justice Mellon referred to, there were 7 incidents, nationally I think it was, that were referred to by the board, Charities Board. And her view was that these were of minor nature. So even though they were illegal actions, they were of a minor nature. There was no charges laid, or there might have been low-level penalties laid. So, and they were appeared to be motivated by deeply held concerns. So not necessarily saying that that was what Greenpeace necessarily believed, but that was potentially what individuals. And Justice Mellon then referred to what the Supreme Court said in the 2014 case, and she said that isolated breaches of the law, even if apparently sanctioned by the organisation, may well not amount to a disqualifying purpose. And I suspect that that's really what she was relying on to push the matters of illegality to one side. And I suspect this pretty much comes back to what I was saying earlier, was that there was perhaps an inevitability of this decision, that even though these matters were raised and are of concern, and I've heard them time and time again, in fact my students raise it constantly when I talk about these cases, and friends of mine also talk, I don't have many friends in that case because I keep talking charity law at them, but people say, but they do illegal things, or Greenpeace does illegal things, why does the courts not say anything about this? Justice Mellon has, but it's been almost brushed under the carpet, perhaps in a way to say, look, maybe we do need to make this organisation charitable now. Perhaps now is the end of the line for it, because people are shocked when they hear that Greenpeace is not charitable in New Zealand. So, just as a thought of what that might actually be.
Thanks, Juliet. Jennifer, Kate, you want to add on the question of illegality? Go for it, otherwise we can move on.
Well, I just think that the comments in the Family First case about the social compact and the fiscal benefits coming with some sort of yoke, some sort of restraint on what you can do, and not confining that constraint to any sort of illegality, just a general, you better behave yourself, is very concerning, I think. And Justice Williams said as much.
Great. Now, there's some comments in the chat that take us to the question of balancing benefits and detriments. And, in the wake of Greenpeace, this is a question that seems to loom large now in New Zealand charity law in cases where political advocacy is on the table. And I just wonder, Jennifer and Kate, in Family First, to what extent did the court grapple that question? Once you apply the public benefit test here, how do you even identify relevant benefits and detriments, and how do you weigh and balance them? Was that something the court took an interest in, or was it a question that just didn't come up?
If I could just start, there was a bit of wriggle worm going on here, because it wasn't clear that Family First were advocating against same-sex marriage. So, and of course, as you would imagine, they were at pains to point out that they were not advocating against same-sex marriage. But so I'll hand on to Kate. But the factual premise of that question was not conceded in Family First.
Now, I agree with Jennifer. I think Family First was particularly trying to convince the court that some of its more extreme beliefs were not advocating against the opposing view, but just that they were educating the public to think about the benefits of, say, same-sex marriage. And hitting your children, and some of the other more extreme views that they had expressed, by trying to balance that fine line between advocating against something and positively reinforcing the view that they wanted. So it's a difficult line, and I think that charity law cases do have that difficult line. I mean, looking at the Latimer case, there have been other cases which have said that the factual situation in Latimer, the entity was not regarded as having a charitable purpose, but in Latimer the court found that they did have. So sometimes I wonder, as in all of these cases, whether it's more about the vibe, to use that word that the Supreme Court used, rather than any really analytical analysis of the facts. It's just, in Latimer it seemed like a great idea to assist these people to appear before the Waitangi Tribunal, but in Greenpeace, until the Supreme Court came along, it wasn't a good idea to allow environmental advocates to go out there and board other ships, in pursuit of their advocacy purpose. So to echo the words of that great Australian classic, it's the vibe and it's Mabo, although I have to say Mabo was never mentioned.
Thanks, Kate. We've come to the end of our time for this session, so I just want to once again thank all three of you. I would encourage everybody to look at the chat, which has been really quite stimulating, and also Murray Baird's question, which is the one that hangs over all our heads in the wake of Greenpeace.
Could I just say one more thing quickly? First, as an entity, Clan should acknowledge Professor Matthew Harding for being the brains behind the whole intervention, in the sense that Matthew was the one who wrote the very eloquent submissions. And so thank you very much to you, Matthew, for all that work. And to point out that those submissions should be on the Clan's website. So
They are.
Are both sets, Matthew, both the submissions before the court generally, and also the submissions on the education versus propaganda aspect, the second line? Anyway, we'll make sure that they're both on the website. Yeah. Thank you.
That's kind of you to say.
I just echo that, Matthew. Without you, this case would have consisted of Jennifer and I standing up and going, something a lot less than we were able to achieve. So thank you very much.
It was a pleasure and an honour to be involved. Okay, thank you all three.